My guest today is Jeremy Rosenthal, an accomplished trial lawyer who knows how to put cases together and tear them apart. He was a prosecutor before becoming a defense attorney. Thanks for joining us. Appreciate you.
Thank you, Bruce. Thanks for having me.
So closing arguments about to begin. The jury may get the case tomorrow, so let's start with this. Do you think the prosecution proved the technical elements in this case?
I think they did. I don't know that the jury's going to be satisfied with it. You've got two essential parts to this evaluation to decide whether or not the elements have been proven. You've got the judge who's listening for whether or not the case is legally sufficient. And the judge has basically decided that the technical points have been proven. The question is does the jury believe them? You remember last week when the defense made a motion to dismiss the case, which is standard, it's pro forma, it happens in every single case. The defense made a motion to dismiss the charges. Had the prosecution not met those really technical, hyper-technical things, the judge would have tossed the case. Think of the judge like a tennis referee, okay, or a tennis judge. I don't know if they're referees, whatever. But think of the judge like that, right? The judge's job is not to decide who's the better player. The judge's job is not to decide who wins the point. The judge's job is to decide if the ball lands in the square. That's it. And when the prosecution calls witnesses, they don't have to, the judge doesn't make a credibility evaluation. The judge just decides if the evidence is what we call legally sufficient. If it's legally sufficient, then the jurors decide just how good it is. They decide if the serve is Serena Williams or a Jeremy Rosenthal serve, right? The Serena Williams serve being a lot harder to return. The Jeremy Rosenthal serve, if it lands in the square, you're going to be able to mash that thing right back down into my throat. So that's a good way to sort of think about the technical aspects here.
So there are boundaries, and the judge has to say, okay, you've fallen within the boundaries, and if not, then we're not playing legally here. So in looking at the prosecution's case, do you think they missed anything?
The hardest part of this case, Bruce, is the emotional part of it. If we were to say that cutting the tag off of your mattress is a crime, the issue is and you may so if you take two cases, let's say you take a case of cutting the tag off the mattress, which I don't think is actually a crime. I think it's a civil penalty, but we all have heard growing up that that's a federal crime, right? If you cut the tag off your mattress. And then you take a child exploitation ring. Let's say you've got a defendant who confesses to both, right? And then you try him on the mattress cutting case, even though you've got a confession, and maybe the guy says, I'll do it again. I'll cut every tag off of every mattress in my house. The jury may acquit that guy even with a confession, even with a promise that he'll do it again. But you take a child exploitation ring, right, and somebody who confesses to that and says they'll do it again, you're hooking that guy up every time, right? Then what's the difference? The difference is the emotional quotient, right? The hardest part of this case, and what did the prosecution do or not do, that's the issue. Did they make the jury care about it? Because it is a technical prove-up. So that's the issue, right? Did the prosecution get there? They spent a while talking about a current affair, the tape, trying to put the Trump campaign in a state of disarray back in 2016 in October. So they're trying to give that emotional issue legs. But that, if there's anything missing from the case, it would be that.
So there are so many emotional cues that were given in the courtroom, and this one was a big one. There are courtroom observers who say, given the contentious drama in the courtroom between Judge Marchand and the defense's one and only witness, Robert Costello, because Donald Trump didn't take the stand. This happened last week. The defense lost points because the jury takes the cue from the judge because of that contentious confrontation. What do you think? Disastrous for the defense?
I think that was a bad thing. I think that was a bit of a self-inflicted wound. But let me put it to you like this, let's kind of look at both sides of this. All right. So from the defense's standpoint, if I'm Todd Blanche and I have a witness who comes to me, who is a former federal prosecutor, who's a guy who's got on paper some instant credibility, and he says, Michael Cohen told me he made this up. you have to call that guy and put him on the stand. If you don't, you're flirting maybe with your law license, right? If there's an appeal and that appeal is ineffective assistance of counsel, not only that, Donald Trump's going to blame you if you lose that case after you don't call that witness. So it's really hard to justify not calling him. That said, when you're in a trial like this, in its days, months, weeks, the jury, it's a closed group of almost friends at that point, including the judge, and the judge is the tour guide to the whole thing. You grow to like the judge. If you talk to jurors who spend a month or more in trial, most of them will tell you glowing reviews about the judge. That's the authority figure. They like him. And then you inject Robert Costello into this. The guy gets up on the stand, starts mumbling under his breath, starts audibly saying things that you can hear in the back row about the judge. I mean, what do you think the jury's going to think of that guy? They're not going to like it. And when the judge tees off on the guy, I think that they're going to see that they're probably going to side with the judge in that scenario. The only way that Costello's shenanigans, if you will, work is if the jury already hates the judge. Now, maybe so from that standpoint, if the jury was there emotionally, then maybe Costello is fine. But I don't know that guy did a whole lot of good for the defense. I think it was a self-inflicted wound. That said, going back to the first part, I don't know if you're Todd Blanche, how you don't call that guy. And there are some times in criminal defense, you're going to be shocked to know that you just have to put a witness on the stand and then watch the whole thing through your fingers and just get him on and get him off and hope to sort of limit the damage. He said his piece, but you're really going to go after Michael Cohen in closing arguments. And so you get Costello on and off, and then you live with the collateral damage if there is any.
And look, the reality is for the defense, they only need one juror. So, and we'll get to that in a minute. So talking about credibility, you brought up Michael Cohen. Was it the right move for the prosecution to build its case around Michael Cohen and make him the star witness?
I look at that and I ask myself, what choice did the prosecution really have? Cohen is certainly a central figure to this whole thing. And with Cohen, I guess if it's not Cohen, then who is the star witness, right? Hope Hicks, maybe. But she's almost sort of incidental to it, right? A little bit after the fact. I don't have any problems with the prosecution strategy and how they approach this. I think that they knew that they had to live with Cohen. And I think that they did probably have to call that guy if they wanted a guilty verdict, because you don't call the guy at the end of the case. Donald Trump is standing up, his lawyer's standing up and says, where's the main guy here, right? Where's Cohen? Where's the guy we've been hearing so much about? I think you lose far more points by doing it that way than you do if you just put Cohen on the stand, do your best to inoculate him. Ladies and gentlemen, or Mr. Cohen, tell the ladies and gentlemen of the jury, tell them about the perjury, tell them about the tax fraud, tell them about pleading guilty in this case. So that way you at least try to manage it. But what they did was they called a whole slew of witnesses before Cohen with the whole intent of corroborating. It's what you might call a paper cut strategy. They paper cut Trump, paper cut him. They called a whole lot of witnesses that Trump really just couldn't land a glove on. David Pecker, Hope Hicks, the lawyer in the case. You've got people who they're calling that are, this is the lady who is right outside of Trump's office. You've got all these people that Trump really can't get a glove on, and their sole job is to make Michael Cohen more credible. Now, and then Cohen gets up there, he does his thing, a bit of a hole in the side of the battleship as he admitted to stealing from Trump on the last day of trial. That was a pretty tough blow for them, but I don't know that the prosecution had any real choice but to build their case. And if you're going to build the case around Cohen, I think that they did as well of a job as they could fortifying his testimony.
Yeah, and the public needs to know this isn't about hush money payments, because hush money payments aren't illegal. And for the jury to convict Trump, the prosecution needs to prove to the jury that Trump knew he falsified the records and that he did it for political reasons and to keep the public from knowing that he made the payment to Stormy Daniels. A bit of a technical challenge. Is that going to be a struggle for the jury?
Very well, potentially. Again, what you got to get the jury to care about it, right? I mean, if you've ever had jury duty, and for those viewers who are watching, who've ever had jury duty, it really is about the scales of justice. In a 40,000-foot view of jury duty, a jury walks in, they want to do the right thing. And they also want to follow the law, but they're not going to follow laws that they don't agree with, or they're not going to follow laws necessarily that they think are too harsh. If they think it's too harsh to have a felony over something technical, then they might find a rationalization to acquit. It's like a speeding ticket. If you were on trial for speeding, and I don't know, Bruce, if you're a fast driver or not, maybe if you should never text and drive it, not, at least not unless you're as good at it as I am, right? But let's say I'm caught texting and driving, and in Texas where I live, that's a ticket. They write me a ticket. I go on trial for it. And then the prosecution says, well, ladies and gentlemen of the jury, the sentence is death if he's texting and driving. But you're only here to decide whether or not he was texting or driving. The jury is not going to convict in that instance. They're going to find some rationalization. They'll find some minute thing in the law to acquit if they think that the charges, if they think that it's just too much, too heavy-handed. And that's what you could see here. That's the danger in bringing such a technical prosecution against Donald Trump, is that if the jury does think, look, the only reason you're on trial for this is because you're Donald Trump, and not saying that what you did, we may agree all here that what you did was illegal, but that's how juries work. That's how they think. That's how they go back there and have the huge scales of justice, right? That's how they balance it. You could see a jury nullification verdict, which would be a not guilty if the jury just thinks that this is too severe. Now, they won't say that out loud. I mean, they won't talk about it. They'll give some other reason, but you could definitely see that.
So given what you just said, given there are so many technicalities, how much of a role will guidance from the judge in reaching a verdict play in whether or not Trump is either acquitted or convicted?
The judge is probably at this moment reading the jury charge to the jury, and that's the manual. That's the whole script of things that the judge says to the panel. And at that point, I mean, it's they always skip reading of the jury charge, if you will, on all the Law and Order shows. And if you watched A Few Good Men, well, they didn't get to the jury on A Few Good Men. Maybe that's a bad example. But you know what I'm talking about, My Cousin Vinny, right? They skip that part of it. It's very technical, but it's the judge talking directly to the jury. So the judge is going to give a jury charge, which is anywhere between 200 and 650 pages of pure straight legalese. That is very serious sounding. It's very it's very precise. It's very technical. But in that charge, you're going to see the burden of proof and definitions about the burden of proof. You're going to see the Fifth Amendment, that it's going to have an instruction in all likelihood that says the defendant has elected not to testify, and you can't hold that. You can't consider that for any reason. It's going to have legal definitions for all the charges that have been brought. So when the jurors go back and they have a question trying to resolve something, they do that, right? We want a jury to have a binary choice. We want them to just check a box, guilty or not guilty. But there's so many questions, and they're not lawyers. So the judge's instructions are fundamental. And more importantly than anything else, the judge's instructions, if they're not done properly, are a huge trigger and a huge tripwire for appeal. So those have to be very precisely done. And it's for the reason that it is the judge talking directly to the jury that the appellate courts take it so seriously. Because any communication from the judge to the jury has to be neutral, neutral, neutral. And it's really critical that the jury charge is drafted that way.
But if memory serves, Judge Merchan already said to convict Trump of felonies, the jury doesn't need to unanimously agree on what predicate crime he committed. That issue is central to the prosecution's efforts to convict him of felony-level falsification of business records. And there was some back and forth on that. But in the end, it's important in the jury's decision-making process. Take away the legalese, simplify it for us. Tell us why it's important. And that may be crucial here.
Okay, I'll do my best because it is a ridiculously complicated principle that we're cutting apart here. A jury has to be unanimous as to one crime. The crime here is falsification of records. The problem is that they're alleging it 2 or 3 different ways. So the predicate offense would be Donald Trump. That's just a way of saying, did you falsify for tax reasons, or did you falsify for the election? What the judge is saying, really based on New York law, is, folks, it doesn't matter. As long as if 6 of you can say this was for tax purposes, 6 of you can say this was for the election, either way, he is guilty. If you go to the store, if you go to Target or Walmart and you can pay via debit card or you can pay via cash, either way you've paid. That's what the judge is saying. If you believe that he did this for tax or that you believe that he did this for the election, it does not matter. That's when we talk about the predicate offense. So that's a very technical point. Hopefully I made it a little easier because it is very, very hard. And if this case does get reversed, that will be the reason why it gets reversed.
Now, what's interesting here is that you do have 2 corporate lawyers on the jury, so it's doubtful that they would overlook some of the legal elements of the case, even if some of the other jurors may not be as focused on them.
Interesting decision in putting lawyers on the panel. You're always, when you're selecting a jury, you can't win a case during jury selection, but you can darn sure lose it in jury selection. And lawyers are really, they get a lot of extra attention when they have jury duty, because there's a really good chance that lawyer is going to be a foreman. There's a really good chance that juror is going to decide your case, and that juror may be the foreman, because the jury goes back to deliberate, and they're gonna look and say, well, we don't understand any of this stuff. You're a lawyer. Why don't you do this? So those lawyers carry extra weight in the jury room. And yes, you are correct that the lawyers tend to take technical things more seriously. There was a district judge that I used to practice in front of. He's now retired. I'm obviously very young, if you can't tell, much younger than he. But he has a saying, which I really like, and that saying is, there's no such thing as a technicality. When you think about it, every element of every crime is there for a reason, isn't it? And if that element isn't proven, that's a big deal. So the judge would say there's really no such thing as a technicality. And the lawyers who are on the jury for Trump in this hush money trial, they very likely have that attitude as well, which is why the prosecution might have been okay putting him on there. For the defense, when you see that somebody's a lawyer, you kind of stick your finger in the air and lick your thumb and put it into the wind and think, okay, how dangerous are these guys? Because you do have to recognize that they are potential foremen. So you do have to pay extra attention to that. But that's a great point. And when this case is over, if one of those 2 lawyers is the foreman, and then we start listening to what they're saying afterwards, and they were really hooked on some of that technical language, Bruce, you'll know that you were right.
And you never know what juries are going to do these days anyway. How long a jury is out can be very telling in a number of ways. We explore that on Path to the Polls after this quick break. Stay with us. My guest, Jeremy Rosenthal, an accomplished trial attorney. He's been a prosecutor, he's been a defense attorney, and he's prosecuted successfully more than 200 cases. Jeremy, it'll be curious to see how long the jury is out. Expectations for these deliberations?
Really technical charges. They've seen a lot of witnesses here. This is going to be a longer deliberation, and for no other reason. Even if they go back there and everybody is in agreement, they're going to take a long time just for no other reason than they're just going to want to measure twice and cut once. So I do think that this is going to be a bit of a longer deliberation. It's really hard to read into the length of a deliberation, particularly on a case like this. If this was a murder, if this was an assault, if this was some other type of violent crime, a quick verdict is almost certainly going to be for the prosecution, and then a moderately quick verdict sometimes is for the defense. But then the longer and longer, as a defense lawyer, the longer and longer it stretches out, the less and less I like it. But it's a junk science. I think anybody who knows what they're talking about would tell you that it's really impossible to read something here, particularly in a case like this, because it's so technical. These guys have a lot of evidence to go over. Not only that, it's been over a long stretch of time. They may not remember things. So I think that you're going to see quite a long deliberation here.
Yeah, and I'm curious to see how many times they go back to Judge Marchand for instructions. One of the jurors, and this kind of surprised me, who made it onto the jury, said he got his news from two different sources, one of which was Trump's Truth Social. So I think he's going to be more likely to want to believe anything the president says. That said, any concerns about a hung jury or a mistrial?
For sure. You've got a couple concerns there. One is that you get a deadlocked jury, right? I'll tell you this much. Experience tells me that you need a friend on the panel, because they're going to go back there. Those guys are going to work on each other, and they're going to work on each other hard, because they're going to want to reach a verdict. And kind of what I mean by that is, let's say that the person who gets some of his news from Truth Social, let's say he is a mole, if you will, and let's say he's a dug-in Trump person. And if the other 11 people are conviction votes and he's the only one standing there, he's going to have to sit there with his arms folded for several days. And that takes a lot of fortitude. A lot of times what will happen is somebody on that island, if they're alone, a lot of times they'll lead the charge the other way, for the reason that they just don't want to be seen as being that obstinate. But I think to the point is that if he's got a friend or two on the jury, if somebody who is like that has a friend or two on the jury, it's a lot easier for them to hold out. It's a lot easier for them to kind of hang the jury. I would really be surprised if you had a hung jury based on somebody who's like that, one way or the other. I really would, only because socially speaking, you're in a room full of 12 people, and it's really just hard to stand your ground that long. The judge, as you've noted, will probably give multiple instructions to the jury. The jury can write a note and ask for more guidance, or if it looks like it's a deadlock, the judge can call the jury back into the room, gauge everybody's body language, right? See how much do you guys hate each other here? See people looking at each other and people nodding, things like that. So I would be, and that's not to say that you might not have a hung jury. You may very well have a hung jury. I just don't think that if it is, I don't think that that's kind of what happens. Again, unless somebody like that has got a friend or two on the panel. And I think it just takes a little bit of time. Yeah.
I was going to say, with so much time invested in this case, judges, they don't like granting mistrials.
No, not at all. And they put a lot of work and effort into this. You want to get this, you want to get the horses into the barn. You want to get this thing done. It really, Bruce, to use a legal term, it sucks to try a case again, and it sucks to hang one. Judge Marchand probably has, I'm just guessing, somewhere between 2,000 and 3,000 cases in front of him. A lot of these are inmates. A lot of these are probably street crimes that you just need to keep the wheels of justice moving. And a white-collar case like this clogs your docket like a hairball in the sink. It's not good. You want it done. And the defense wants it done, and the prosecution wants it done. So there is a lot of pressure to get a verdict on these jurors and to get something other than a hung jury.
If found guilty, Trump will most certainly appeal. Have you seen any appellate issues pop up?
The best issue that I think is that unanimity one, which you pointed out, Bruce, which is based on the predicate offense. Don't want to put everybody back to sleep on that issue, but in America, what we want to have are singular issues and singular crimes that a jury can all agree on. and that you have a unanimous conviction on. And to give everybody just a bit of a flavor on that, take driving while intoxicated, driving under the influence. Your breath or blood, if it's above the legal limit, for instance, that can be one reason why you convict. If the officer says, well, you're not behaving normally mentally, that could be another reason. You're not behaving normally physically. The law gives you those reasons. A jury does not have to agree on those three predicates. That's another example of why the predicates are the way they are and why you can sort of merge them. They made an objection about Stormy Daniels, that her testimony was too prejudicial. You're going to lose that on appeal. The judge is given a wide degree of discretion. When the judge cleared the courtroom the other day, that's potentially playing with fire. I'll tell you what I worry about more than anything. I worry about the breaks that have been going on in this case and the fact that the jury's not sequestered. If you come back, if they convict Trump and we learn in a week or 2 weeks or 3 weeks, if we come back and we learn that somebody got worked on by an outside influence, somebody saw a headline that they weren't supposed to see, somebody had dinner in a bar, and on the news was some headline that they weren't supposed to see, that could be a big reason to try to do that again. And we saw something very similar in the Murdoch case, but that would be also something that would be pretty big. But those just kind of thinking out loud would be the top appellate issues that I see right now.
And it's unlikely if he gets jail time that he would be taken out in handcuffs.
Right. I think if he gets sentenced to jail, first off, I'll tell you this much. I was reading a little bit last night in New York State, in Manhattan, in the superior courts. Only 1 out of every 10 people who've been convicted of this crime go to jail. But already Michael Cohen did house arrest for it. So Trump could very likely get something like house arrest if he did that. But what he could do is, if he is sentenced to jail, what could happen is that Trump could post an appellate bond, and then he's out while this is getting hashed out. And that could take a couple of years. Another thing that can happen is the judge could say, Mr. Trump, I'm going to sentence you at the crack of October. So we could get a really long delay for sentencing, although in state court, it's typically pretty fast. But no, I would be really surprised if Donald Trump is taken into custody.
So I know you don't have a crystal ball from what you've seen, what you've heard, knowing juries are an unknown. And from your experience, do you have any expectations?
This smells like a guilty verdict to me. I think the prosecution did a really good job of walling Trump in, emotionally doing their best to connect with the jury, inoculating Michael Cohen, making his testimony pretty safe. If I'm giving the closing argument for the prosecution, I'm kind of focusing on some of the things that you pointed out earlier, right? I'm giving the jury what they call jury putty, which is, why does this matter? Why is this important? Why is it important that you take a stand? Ladies and gentlemen of the jury, do not be intimidated by this man. Do not be intimidated by his team. You look at Robert Costello. That man comes in here. He thinks he's better than this whole thing. He thinks he's better than our judge. He came down here and talked down to all of you. That's what I'm trying to convey to the jury to get that conviction. If I'm the defense, I'm really picking my spots. I would anticipate that Todd Blanche gets up. We know he's going to get the jackhammer out. We know he's going to go after Michael Cohen. We know he's going to go after that theft issue, and he's going to talk about how the theft issue was germane to not just the fact that he's a thief, the fact that he was stealing in conjunction with this very transaction. That's a big deal. And I'll just give you, Bruce, just a bit of a quick personal connection. I know that I saw that you were high school friends, it looks like, with Bob Saget. And I watched your interview there, and your talk with him, very emotional. I went to high school with Todd Blanche, Trump's lawyer. He beat me out to be the leadoff hitter for our high school baseball team. So Didn't know he went to law school. Apparently, he's doing okay with all this. But Todd's done, I think, a really competent job, and he's played his hand as best I think as he can, given what it is. To go back to your original question, this is probably a guilty verdict. But again, if I'm right, it's because I'm a genius and I have a ton of experience. If I'm wrong, it's because I said the word probably and I hedged it. We don't know.
You used the word putty, and we all know that putty is malleable in the hands of a jury. Jeremy Rosenthal, I appreciate your time and your expertise. One way or the other, we should know sometime in the very near future, certainly before the presidential election in November. Have a great day, and I appreciate your joining us here on Pass to the Polls.
Thank you, Bruce. I enjoyed it.